The knee on the neck. Well, guess what, folks? Take a look at what you're looking at right here. That is from the police training manual. And then you've got George Floyd there. So where this all comes from is from a motion to dismiss. A motion to dismiss that was filed by Derek Chauvin's attorneys, saying that the knee on the neck is part of his training as a Minneapolis police officer. And there we see it in the manual on the left, and on the right is what we all have seen in the video of Officer Chauvin. So is this a game changer? How does this impact everything? Let's bring in our team with me right now. Joining me, Julie Janae, CourtTV Crime and Justice reporter, Ashley Banfield, special contributor, and Michael Ayala, CourtTV anchor. So this is all part now of a motion to dismiss by Derek Chauvin, the knee on the neck officer, who is claiming that the knee on the neck is part of his training. Julia Janae, explain to me what they filed here and what their argument is.
This is a motion to dismiss. Derek Chauvin is arguing or attacking the probable cause in this case, saying that the state doesn't have enough evidence for this to even go forward, hoping that the judge will rule in his favor at the September 11th hearing that is upcoming, making these arguments. And it's similar to some of the arguments that we've seen from the other officers in this case, Tu Tao, Jay King, and Thomas Lane, who have also filed their motion to dismiss. But this one, he is focusing on his conduct. These other officers have distanced themselves from his conduct, but he talks about his knee being on George Floyd's neck. And here's some takeaways from that document. He highlights that there was no bruising, no damage to the neck structure of George Floyd. And that's something that they are relying on based on the autopsy report. They're also saying that the 2018 training materials that show what the protocol is for the Minneapolis Police Department, that authorizes a knee on the neck in certain situations, even saying that Chauvin was calm and professional throughout this situation, throughout this incident, and of course making those arguments trying to minimize the impact of his knee on George Floyd's neck. So in that motion to dismiss, a lot of different factors, a lot of different arguments being made by this officer in advance of that hearing that's upcoming.
How powerful is it?
Vinny, you know, and you know this, if you've done enough of these cases, you look at the paperwork, and these cases begin to magically appear before your eyes. It's like Beethoven. He would start playing, and these symphonies would show up. When I read through this paperwork, because that's what we do here at CourtTV, right? We go through the minutia. First of all, I was shocked to see that. But one of the main issues in this case legally for Chauvin was there came a point, okay, you can argue that he was actively resisting, and at that point, according to their manual, you can use neck restraints. But there comes a point where everyone is telling him, look, he's not responding anymore, right? Even his own partner saying, should we turn him on his side? This is not good. And he doesn't. And I want our viewers to get familiar with the very important word here. It's called excited delirium. You hear Chauvin say it. He's worried about excited delirium. That's what he's going to use to explain why, when he was no longer responsive, he continued with the knee on the neck. Because that, when you talk about excited delirium, it's about people who use drugs, which they're going to claim they saw him using. That's why they're talking about the tablet on the tongue. Bizarre behavior, we saw that. But eventually it gets to something that's called superhuman strength. Oftentimes people in that position, they show superhuman strength. And this, Vinny, that picture shows how you're supposed to restrain people when you're afraid for excited delirium. Unbelievable. This is a game changer, Vinny. It's going to be tough to overcome this training instruction picture that shows exactly how he was doing it by the book, Vinny, by the book.
It's problematic. It's problematic for prosecutors. Julie, today, let's talk about prosecutors. Did they address this in any of their court filings, the training manual and what it says to do and what it says to not do, and what's their take, their interpretation of all this?
Absolutely. The state has been talking about the training manual and training protocol from the beginning. They didn't show that picture that we see in the defense filings, but they have said all along that this was not according to protocol and that it was dangerous. Take a look at what they actually put in one of their responses to another motion to dismiss. They said that officers are also trained to employ a neck restraint, and that is defined by compressing both sides of the neck, either with a person's arm or leg, but that they can only do that when the person is not passively resisting. When they are passively resisting, that is not a situation, according to the training manual, where that kind of restraint can be used. When they are, when it is a higher level of resisting, where the person is actually trying to take over control of the officer, they are actively resisting, that is the only time that they are able to use that maximum restraint. So restraint and resistance are going to be the two key words that these parties are going to have to bring in their supporting evidence to show what George Floyd's level of resistance was and what these officers' level of restraint was during this incident.
Vinny, you know, I don't want to speculate, but I can tell you that first video that we played at the beginning of the segment, you actually hear Chauvin say, because they're telling him he's not responsive. He's not responsive. And he says, I'm worried about excited delirium. Right? So it's
that's
gonna
actually
come down,
Lane, though. That's
I'm
not
sorry.
Chauvin. I think that's Lane. I
Oh,
think
that's
that's
Lane?
Lane, Michael. That's the
Okay, but
rookie. That's the rookie.
That's the rookie saying it. And I think there were conversations going back and forth. But the prospect of excited delirium is there. If a rookie knows it, Chauvin knows it. And again, he's performing exactly to the book. That's what's most devastating about it. He's performing to the book. So the question is going to become, how much leeway is the jury going to give him to make that argument? Are they going to look at this and say, at some point, you've got to see that this has now become a dangerous situation and you're continuing? There really is no need. Excited delirium is out of the window. Stop it. Stop saying it's not going to work. Or are they going to give him the benefit of the doubt here? And that's where, you know, all it is, Vinny, is a reasonable doubt. It's not that difficult, and this certainly sullies the waters.
Yeah, that is a problem. We've been saying it from the beginning. I mean, every case is difficult to prosecute because you have that burden.
Yes.
And we need that burden because of wrongful convictions, like a case Ashley will be talking about in next hour. So we need that burden. But we're going to continue to cover this story, folks. And when new information comes out, you'll hear it right here on Court TV with this team of incredible legal journalists.
Analyze these cases as a lawyer would. First on the docket, former officer Derek Chauvin, that's right, the officer charged in the death of George Floyd, wants his charges dismissed. And you may say, oh my gosh, Scott, everyone has seen the video of George Floyd. It's obvious and it's apparent that George Floyd died at the knee of the officers in this particular case. Well, guess what? We've talked about other officers in this case who have filed motions alleging the same thing that George Floyd attorney is asking the court to do. And what former officer Derek Chauvin, through his counsel, is asking for is for the judge to drop all the charges. And their argument is hey, judge, this man who was 46 years old at the time of his death died of a drug overdose not caused by the officer planting his knee in the back of Mr. Floyd's neck. Mr. Chauvin's attorney is a gentleman by the name of Eric Nelson. Now, ladies and gentlemen, you may not like this. You may say, no, these officers killed Mr. Floyd. This attorney is doing his job. He has support behind this theory that he is submitting to the court. Now, I think ultimately it will not be the court dismissing these charges, but ultimately if a jury decides whether Mr. Floyd died because of his own conduct or that of the police officers will ultimately be the decision of the jury. Now, quick recap. Mr. Chauvin is charged with second-degree unintentional murder, third-degree murder, and second-degree manslaughter. He's pled not guilty to all the charges. Now, according to filings made on behalf of Mr. Chauvin, through his counsel, it is alleged that then Officer Chauvin was acting upon his training the training that he received from the Minneapolis Police Department in the use of maximal restraint techniques, and did so out of concern that Mr. Floyd might harm himself or the officers as they were struggling to arrest him. The Minneapolis Police Department's own policy states that maximal restraint technique says it, quote, shall only be used in situation where handcuffed subjects are combative and still pose a threat to themselves, officers, or others, or could cause significant damages to the property if not properly restrained, end quote. And Mr. Nelson, Mr. Chauvin's attorney, included that quote as well as other training materials as it related to this maximal restraint techniques. Now, Mr. Nelson argued on behalf of Mr. Chauvin in his motion that the training materials appear to contradict a statement made shortly after the incident by the Minneapolis police chief that he had not seen anything that says you place your knee on someone's neck when they're face down and handcuffed. And Mr. Chauvin's conduct basically states is that any risk created by Mr. Chauvin conduct lies largely with those who train the Minneapolis Police Department officers and those who approve such training, and not Mr. Chauvin, since he was just following his training. Now, where this is really going to get exciting is that Mr. Nelson, on behalf of Mr. Chauvin, also cited the autopsy conducted on Mr. George Floyd that found that fentanyl and methamphetamine in Mr. George Floyd's system, a combination of drugs that Mr. Chauvin says is known as a speedball. He also specifically noted in his pleadings that the Hennepin County Medical Examiner's postmortem report showed that Floyd had hypertensive heart disease, hypertension, and sickle cell trait. Floyd also purportedly told the officers that he had contracted COVID-19 and was still positive for the virus at the time of his death, which was confirmed during the autopsy. Mr. Chauvin's attorney states simply, Mr. Floyd could not breathe because he had ingested a lethal dose of fentanyl and possibly a speedball. Combine this with sickle cell trait, his pre-existing heart conditions, Mr. Floyd's use of fentanyl and methamphetamine most likely killed him, not Officer Chauvin, as his attorneys argued. The attorneys stated, adding fentanyl and methamphetamine to Mr. Floyd's existing health issues was tantamount to lighting a fuse on a bomb. The attorney also added a footnote quoting the Hennepin County Medical Examiner, Dr. Andrew Baker, saying, quote, if Mr. Floyd were found dead at home, alone, and no apparent causes, this could be acceptable to call an OD, an overdose, end quote, ladies and gentlemen. Now, a lot of people aren't going to like this stuff, but these are facts. People always say, oh, attorneys are just out there making stuff up. No, and I guarantee you, as I've stated before, these officers are going to have experts that are going to come in and state that the drug use of Mr. Floyd, his pre-existing medical conditions, were a significant factor, and that you cannot say that these officers caused the death of Mr. Floyd. Now, the prosecutor will probably argue that even if that was there, even if those drugs were there, that's not what killed him, and that these officers are still somewhat negligent, or may say reckless manslaughter, because they didn't call the police early enough. Now, the problem with that particular argument is that the prosecutor has locked themselves in based upon all the hype of this particular case early on, saying that these officers actually killed Mr. Floyd. Now, we know the family of Mr. Floyd, through his attorneys, brought in some heavy-duty pathologists to say that it was a homicide, which completely contradicted the official medical examiner's version. The medical examiner ultimately did modify his position a little bit, stating it was in fact a homicide, but the reality of it is this will be a battle of the experts, and a jury is going to have to decide whether Mr. Floyd was killed or whether Mr. Floyd was somewhat at fault based upon his drug use in this particular case. Taking fentanyl would certainly cause one to breathe. And as you may recall, the video from the body cams that were released show that Mr. Floyd was complaining about not being able to breathe prior to ever being placed in the car or on the ground. I'm sure the defense attorneys are going to argue that was a symptom of the fentanyl use and that is what is responsible for the death of Mr. Floyd. And the prosecutors, in response to the motion that was filed, stated that they're going to seek an upward sentencing departure from state judicial guidelines if the defendants are found guilty. That trial is currently scheduled for March of 2021. We'll see how that goes, whether it proceeds or not, since many states are on limited schedules as it relates to the COVID-19 matter. Other officers have made the same argument that Mr. Chauvin has in this particular situation. Their position is basically that they were actually acting in Mr. Floyd's best interest because he was acting erratically, resisting arrest, and they were concerned that he was going to injure himself by falling or hitting his head on the sidewalk or being struck by oncoming vehicles or even injuring himself in the squad car. Mr. Chauvin is also stating that he was clearly being cautious about the amount of pressure he used to restrain Mr. Floyd, and he actually pointed out in the video where he was able to raise his head several times while he was prone on the ground. I assure you, the attorney, although he's probably watched these videos hundreds of times, they have expert witnesses, and these are laying out the arguments that the experts were going to make at trial. I believe the judge will ultimately say these are questions of fact that need to be decided by a jury. Either way, that argument is going to upset somebody. Can you imagine if a judge were to throw out those charges? I don't think that any judge has the chutzpah to throw out those charges and leave it to a jury. And then a jury is going to have to decide. And oftentimes jurors are under a lot of pressure from what would happen in the community. Obviously, we've seen what's happened in the community, but that's why I think that this trial needs to be televised from beginning to end so that people can see and hear the evidence. And if a jury returns a verdict for guilty or not guilty, people can understand how the decision